forward to the discussion.
Good morning, and congrats on being at the national finals, even if it's virtual. My name's Andy Levy. I'm a trial lawyer from Baltimore, and I also teach at Maryland's 2 law schools. And I am joining you from a little town called Highland, which is about halfway between Baltimore and Washington, D.C.
Good morning. My name is Chuck Lapp. I'm Executive Director of the Indiana Bar Foundation, and I'm joining you from Indianapolis, a little bit further west. I'm also an adjunct faculty member at Indiana University, and looking forward to hearing from you in just a few minutes. Thank you.
Would you please introduce yourselves and your teacher?
Yeah, good morning, judges. We're Unit 5 from Staples High School. My name is Brian.
Hi, my name is Taha.
My name is Nicholas.
My name is Violet, and this is our teacher, Mrs. Cameraman. Thank you so much for sparing some time to be with us this morning.
Very good, thank you. Okay, so you know the drill. I'm gonna read the question all the way through, and then when I stop talking, you can begin, and that'll start your time for Ellen, okay?
Mm-hmm.
Richard Posner wrote that the American public worries more about invasions of privacy than about summary proceedings against suspected terrorists, curtailments of the freedom of speech of the law-abiding, or the right of the media to publish government secrets. Do you agree or disagree with this statement? Why or why not? To what extent, if any, is privacy in jeopardy today? What protection, if any, do people have from privacy violations by governments or businesses?
The rapid pace of the coronavirus pandemic has prompted world governments to steal privacy rights away under a promise of alleged safety, a dangerous precedent that threatens the future of our civil liberties. National emergencies are often the battlegrounds where we chart a course to the future, where we protect or relinquish our civil liberties, and there has never been a time more pressing.
We disagree with Judge Posner's assertion that the American public worries more about privacy than abridgments of other constitutional rights. Privacy rights are evaporating as other rights, often freedom of speech, are being prioritized in an inherently contradictory situation. In the 2014 case, Snyder v. Phelps, we managed to uphold the First Amendment and protect even the most hurtful speech. However, the NSA's constitutional abuses slipped through the cracks of the legal system, facing little more than public scrutiny. NSA whistleblower Edward Snowden astutely opined that privacy is the fountainhead of all other rights. Freedom of speech doesn't have a lot of meaning if you can't have a quiet space. In today's amplified surveillance state, the American people need to be more worried than ever. Otherwise, our rights will be forfeited to advancing technology.
In 1965, Griswold v. Connecticut established that guarantees in the Constitution create penumbras that institute a right of privacy. However, privacy protections have been greatly weathered away as the value of data has soared in the post-9/11 era. Companies harvest data for political motivations and larger profits. In 2018, Cambridge Analytica mined the personal data of 85 million Facebook profiles without user consent and used it for novel political advertising.
The government, conversely, collects data in the name of safety. Their ability to do so is enhanced in the wake of September 11th with the passage of the Patriot Act, the Freedom Act, and modern amendments to FISA. FISA courts permit the NSA under the PRISM program to perform warrantless, wide-ranging sweeps of data, unbeknownst to users. The USA Freedom Act, for instance, enabled the NSA in 2018 to access more than 534 million records of phone calls and text messages from companies like AT&T and Verizon, 3 times what was collected in 2016.
Modern technology has allowed for the unchecked exploitation of the third-party doctrine, developed in Smith v. Maryland and US v. Miller, whereby information voluntarily shared with someone else is exempt from Fourth Amendment protection. We agree with Justice Sotomayor's concurrence in US v. Jones that the third-party doctrine is ill-suited to the digital age, in which people reveal a great deal of information about themselves to third parties in the course of carrying out mundane tasks. This doctrine amounts to a fishing expedition at the cost of our Fourth Amendment rights.
Currently, we have tenuous protections from privacy violations by the government and businesses. The Federal Trade Commission issued the Fair Information Practice Principles, a set of guidelines for businesses and the government to follow in an electronic marketplace. However, since these guidelines are legally unenforceable, the FTC is inefficient in quelling privacy abuses. To exacerbate this issue, the government can acquire otherwise private data from companies by using national security letters, which allow for the disclosure of enormous amounts of personal data without probable cause or judicial oversight.
While the FTC guidelines fall short, the European Union instituted the General Data Protection Regulation, which can hold accountable any businesses that handle data from EU states or individuals within the EU with significant monetary fines. To further combat the US's patchwork approach to data protection, 7 senators introduced the Consumer Privacy Protection Act, a comprehensive legislation intended to protect a wide range of data, including online usernames and passwords, health information, and photos and videos.
Just as Douglas declared in Griswold, we deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. In this crucial time, we stand at a juncture between unbridled privacy invasions and deteriorating protections from such violations. To tolerate this erosion of our right to privacy would open the floodgates to an eternal state of Big Brother surveillance, invalidating our own foundations of democracy. Thank you. We are now ready for questioning.
All right, thank you very much. And I just remind you to please put your notes away. And I'd like to return us to something you mentioned in your opening statements about companies harvesting data for political motivations and profits, and your mention of the Cambridge Analytica case. So what happens to our personal information when we decide to use Facebook? I mean, didn't Facebook have the right to do that? Or where do you find protection for our privacy when we look to just private industry?
So Facebook does have the right to collect our data, but however, everyone is becoming so much more dependent on social media that Facebook has a moral duty. And I think it lands on 3 different people. The consumer should understand what's happening with their data. The industry should be informing consumers what they're doing with this data. And likewise, the government there should be tight oversight through some sort of legislation to make sure this data isn't abused, like something in Cambridge Analytica.
Yeah, and so Facebook is a private company. So since they're not government-based, they aren't bound by the Bill of Rights and don't technically have a legal obligation to protect our privacy. However, online sites like Facebook and other apps, such as the Polar app, fitness app, that was used by military personnel 2 years ago and exposed the actual location of military bases and private information of over 6,000 individual military personnel. There's more than just a need to protect the civil liberties of individuals. There's actually a national security interest in for these companies.
So I can hear my corporations professor in my brain saying that a corporation has one duty, and that is to maximize its value to its shareholders. If that's true, no moral duty to do anything but that. Do you think that the greatest, knowing what you know now, is the greatest threat to our privacy come from government, or does it come from corporations and private entities?
I think the greatest threat is actually from private companies. The government still has certain institutions like the FTC, which is Fair Information Practice Principles, and states are also passing laws. For instance, New York just passed the SHIELD Act in 2019. So the government still has slight institutions and laws which are protecting privacy rights, but corporations have very, very little oversight, which can allow for much more data abuse to take place.
Additionally, there's very little transparency with such corporations, whereas the United States government in some cases, and for example, the Edward Snowden situation where he leaked the Patriot Act and the issues with the NSA, there is very, very little transparency, and these companies, in fact, do not have, as you were discussing, this right to disclose which information they're collecting. And only in situations of public outrage, for example, with the Facebook and Cambridge Analytica scandal, do these issues arise to public opinion.
So what would you do as far as solutions to that? What sort of response should either government or consumers, or where does the right audience to respond to that?
I think a lot of it actually comes down to, we need to implement, better data protection regulations. So as you see in Europe, they implemented the GDPR. So in there, they have implemented a lot of consumer protections, and stuff like that. So as you can see, like overseas and stuff like that, they're implementing these sort of wide-ranging, very sweeping programs that protect consumer privacy in an unprecedented manner.
I think a great example of this is in Connecticut ourselves. We have pretty robust privacy protections where one of the Connecticut legislation is that the certain businesses have to have measures in place that notify their consumers of data breaches. However, I think we should follow in line with California with their California Consumer Privacy Act, as that is the most robust, the most progressive, and the most protective legislation that we have as of yet in the US.
Given the sort of scope of privacy and online, et cetera, do you think that the federal government is sort of derelict in its responsibilities, or is this a situation where each state should be able to, sort of the federalism model, be able to weigh in?
I think what we're at right now is the federalism model, and we're seeing that isn't really working. States like California are passing fantastic legislation, but other states like New York with the SHIELD Act, they're just not simply strong enough. So at the federal level, we need some kind of legislation to create an agency. I think the FTC is doing a respectable job, but they're simply they don't have enough latitude and enough power to carry out these privacy to quell any privacy abuses. And we saw in the GDPR, every nation in Europe has a privacy agency, and the US should adopt a model like that.
Thank you.
Andy, you're on mute.
Okay. So are these expectations, when we talk about a reasonable expectation of privacy, given all you know, are these expectations reasonable?
Absolutely. In areas where you're having your personal data monitored, that is a reasonable expectation of privacy, as shown in US v. Carpenter and US v. Warshak, which is a Court of Appeals case where they showed that information that you were exposing on email, this personal information, which can be extended to metadata as well, is protected and a reasonable expectation of privacy.
Very good. All right. You're done. Congratulations.
Excellent.
That was excellent. So thank you very much. We'll just go through a bit of feedback. I'm just going to cross-reference my notes. Chuck, I'm so bummed you didn't drill down on them. You all are the first team we've seen to kind of come out and mention the COVID pandemic as kind of a crisis where the government could infringe upon privacy in the interest of national security. And I wish we had more time to tease that out. But kudos to you for anticipating that and making your prepared remarks super relevant to the kind of the current situation. I thought that was great. And as was the rest of your kind of prepared remarks, you took us through the foundation and you hewed pretty closely to kind of what the prompt asked, which was for you to take a definitive position on Posner's statements there. So I liked that. I was even more impressed in the follow-up where we kind of went off in a different direction. Taha, I think it was you who gave me a three-pronged proposal in response to my question of what should we do about this. That was just like extremely well reasoned for being on the spot and not having your notes in front of you. And really, without exception, all of you handled the Q&A with giving us kind of new material that wasn't in your prepared remarks, really showing us that you had studied, way beyond what the textbook kind of gives you. So bravo.
Thank you.
Thank you.
Yeah, bravo indeed. Yeah, and I've summarized my notes sort of, down with Richard Posner, up with Edward Snowden, which was a pretty edgy position to take, but you supported it. Everybody's got opinions, as they say, but you guys really thoughtfully and I thought sort of coherently were able to support the opinions in a structure that made sense. Whether someone agrees with you or disagrees with you, they could certainly understand in I thought a very sophisticated way sort of what underlay your opinions. And that's very difficult to do with complicated topics like this. And you guys really did it so awfully well. So congratulations on really a great presentation.
Yeah, I agree. And Caitlin kind of alluded to it. You covered a lot of what I usually ask in your opening statements. So I was sort of like, well, they really covered that pretty well. So let's see if we can get some other areas. So with the national emergency COVID and things like that. So very nice. And again, I really appreciate it. And again, I think this was referred to by some of my colleagues, but the idea of, understanding what the situation is, understanding the various legal and constitutional frameworks and everything, but then doing the next step to have proposals and potential analysis that you've taken, and potentially, if you've developed them from various research, I mean, that's a whole nother level. And to be able to put those in the context of the current environment and the current sort of constitutional structure and things like that was very sophisticated. So I really appreciated that and enjoyed our discussion. And as we've said before, wish we had more time, but I enjoyed the time that we did have. And so thank you very much.